Did the 1871 Organic Act replace the Constitution? Debunking the U.S. is a corporation myth. The Constitution is the bedrock of the American system of government. It defines the structure of our institutions, limits the exercise of power, and provides the legal framework that guides the nation. But some claim that at a point in the past the Constitution was fundamentally altered or quietly replaced by a corporate substitute that rendered modern laws and constitutional interpretation obsolete. That theory centers on the District of Columbia Organic Act of 1871. Let's settle the question: did that act replace the Constitution or turn the United States into a corporation? The short answer is no. The District of Columbia Organic Act of 1871 created a single municipal government for Washington, D.C. Before 1871, the district contained three separate local governments: Washington City, Georgetown, and Washington County, with different officials, police, and public works. The act merged them into one municipal government with a single local administration to improve governance and infrastructure. It reorganized only the district's local government. It did not alter the U.S. Constitution, change federal sovereignty, create a new form of citizenship, or convert the federal government into a private corporation. Confusion often starts with terminology. The 1871 Act described the new local government as a municipal corporation. In law, municipal corporation simply means a city or local government recognized as a legal entity. It does not mean a private business like Amazon or Walmart. Thousands of U.S. cities are incorporated in the same way. Calling a city a municipal corporation is a legal formality for local governance, not evidence of a wholesale replacement of the national constitution. Another common claim is that language differences, such as Constitution for the United States versus Constitution of the United States, show a change. The Constitution itself has no formal title on the engrossed parchment. The preamble begins, "We the people of the United States." And the phrasing in the text remains constant. Variations in how printers or commentators title the document do not change the legal text or its authority. Some also argue that the district exceeded the Constitution's geographic limit, the 10 miles square, or that the United States declared bankruptcy in 1871. The constitutional clause gives Congress authority over a district, not exceeding 10 miles square, which historically refers to a surveyor's square 10 miles on a side, 100 square miles. Washington's boundaries and the 1846 retrocession of territory to Virginia are matters of historical record and congressional authority, not evidence of a constitutional replacement. And while the Civil War greatly increased federal debt, debt alone is not bankruptcy. The federal government has never declared bankruptcy and continued to function and legislate. If the Constitution had been replaced by a corporate substitute in 1871, one would expect successful legal challenges proving it. Courts at every level have consistently rejected the United States as a corporation and related sovereign citizen claims as frivolous. Examples include rulings that describe such claims as without merit and patently frivolous. No court has ever concluded that the 1871 Act voided the Constitution or turned the federal government into a private corporation. In short, the Organic Act of 1871 reorganized local governance in Washington, D.C., and used the legal phrase municipal corporation in the municipal sense. It did not replace the Constitution, eliminate federal sovereignty, or nullify later amendments in federal laws. Claims to the contrary misunderstand legal terminology, historical context, and long-standing judicial rulings. If you encounter someone repeating the 1871 corporation claim, point out these basics. The Act's purpose was municipal reorganization. Municipal corporation is a standard legal term for cities. Debt is not the same as bankruptcy, and courts have repeatedly dismissed the theory as frivolous.